of the program. And of course, we are very much fortunate today, to have Pieter with us. All right, Pieter Visagie, from Adams and Adams. We've worked with him for quite a while in protecting some of our inventions, and of course, Pieter, welcome. To this session. This is also, UNISA is your alma mater, right? So welcome. But let me just quickly introduce you properly, reading your bio. Pieter is a registered patent attorney. His practice is focused on the drafting of patent specifications and the filing and prosecution of patent applications, both local and abroad. In this respect, Pieter has had extensive exposure to the prosecution practices of the patent offices of most major foreign jurisdictions, including the United States Patent Office, the European Patent Office, the Chinese Patent Office, the Japanese Patent Office, and the Australian Patent Office, and others. Pieter also deals with the preparation and filing of design applications. Technical fields in which Pieter has drafted and prosecuted patent applications include, amongst others, those of nuclear energy, radiochemistry, radiopharmaceuticals, petrochemicals, refrigeration technology, organic chemistry, applied polymer chemistry, mining technology, medicine and medicinal treatments, nanomaterials, and beer brewing. Also has extensive experience in performing IP due diligence investigations for capital investments, both in respect of startups and established companies. So assists a number of clients with their intellectual property portfolio management, is sitting as an advisor on their IP management committees. Perhaps, Pieter, maybe after this conversation, after your talk, we should have a conversation about you possibly, assisting us in this regard and sitting in one of our committees. But anyway, Pieter, welcome. We're looking forward to the talk. We truly appreciate that you've made the time, to actually, come and share with us. We're looking forward to the talk. Over to you, sir. Thank you very much.
Thank you very much, Ayanda, for the introduction. It's good to see your face again. I mean, we haven't seen each other since Sarima, I believe, when we were in the Cape, which was probably 2.5 years ago. So it's good to talk to you. Thank you for the kind introduction and also for the invitation to participate in this lecture series. I'm grateful for the opportunity, and I agree with you, as you indicated in your opening remarks. To emphasize the importance of sessions such as these, and I certainly hope that my talk today will make a positive contribution to the lecture series and also to the attendees. Good morning to all the attendees. I see a familiar name on the list of attendees. Yongama, is it Yongama who was with me at Stellenbosch? I'm just
Pieter, it's a small world.
I was wondering, I saw your name sitting there. Now, it's good to hear your voice again.
Thank you so much.
We were in the same residence at Stellenbosch for, I don't know, 3 years, Yogama, 2 or 3 years probably.
It was for 3 years that we were together there.
No, it's good to hear your voice again. Colleagues, I will then also share my my screen. I've got a short presentation. The presentation, I don't generally like doing PowerPoint presentations. I believe it detracts from the content often. So, but the presentation does speak to the sequence of topics that I wish to address. So it's in that context that I will be sharing it. Can everybody see the screen? Your silence, I will assume that you can see it. If anybody cannot see the screen, please.
We can, thank you.
Thanks, Tigist. I just need to find it on my side as well, so that I can see it myself. There we go. All right. Now, besides for enjoying events such as these, I also find it highly educational, since the topics that I'm requested to lecture on are often ones that I may have a feeling for, but that I never really sit down to characterize. And preparing for a lecture, of course, requires one to really get behind the subject matter of something, and requires you to understand it for yourself, so you can assist others or educate others, or have a productive discussion with others in relation to it. And through that, you'd essentially get your own thoughts about the topic in order. Now, in thinking on this experience of mine in preparing for this lecture, I came to the realization that this is what many entrepreneurs or budding entrepreneurs are also in need of, which is essentially to get their thoughts about intellectual property in order. And it's regrettably been my experience that many entrepreneurs, by no means all entrepreneurs, but many entrepreneurs have a misguided or a deficient knowledge of intellectual property. And that may result in such entrepreneurs suffering severe prejudice in all of the short, medium, and long terms as a result of failures to approach intellectual property in a commercially focused and a commercially relevant way from the outset. Now, to understand intellectual property as a concept in the context of a business, I believe one has to understand the concept of value, which, as I would characterize it in a business context, is the ability to generate revenue. Of course, this is what sits at the core of each and every business, which is this ability to generate revenue. Grocery stores sell groceries, furniture stores sell furniture, doctors render a medical service, and well, lawyers, we all know how incredibly valuable lawyers are to the world, and I will not be upset if you crack a smile at that comment. This is only part of the story, however, since what I've just described relates to the manner in which revenue is generated. Behind the manner in which revenue is generated sits a further consideration, and that is that which enables the manner of generating revenue to be performed in a profitable manner. Everyone can buy and sell groceries, but not everyone can make a profit out of it. And to use a recent example that came across my table, I have an aunt who lives in the Northern Cape who owns a furniture store in quite a small town in the Northern Cape, and she's considering selling this business. Now, this business she not only built up through great investment of her own time, effort, and money, but she also never outsourced or delegated the running of the business. She ran it herself. She had all her supplier and customer relations herself. She knew about product specifications, product quality and service herself, and so on. And she built up this knowledge over more than 20 years worth of involvement in this business and gaining experience in it firsthand and making a lot of mistakes along the way and having a lot of failures, but ultimately being an owner of a business that can, that have stood the test of time for a period of quite some time. Now, if we view her business as a potential acquisition, one can break down the value into her physical assets that she owns, for example, the building in which she operates, if she owns it and the like, and then also the non-physical assets, which include the store's name, the store's reputation, the store's customer lists, pricing lists, contractual relationships, and the like. And that is essentially what would be acquired if one were to acquire that business. Now, the question of assessing value of a business, of course, is, are these physical and non-physical assets enough, or is there something missing for the business to carry on business as usual after it has been acquired? Now, it is here that I believe that you have to take the business owner, and in this case, my aunt's role in the business, into account. There's no guarantee that any subsequent owner of that business would able to run the business nearly as well as she did. And of course, there's no guarantee that it would not be so. It may well be so. But the point that I want to make with this example is that the question of value is a complicated one in a business context. One may acquire, if you look at it as an acquisition, you may acquire various assets of a business, even the name, even the reputation. But if you do not take careful cognizance of what it is that actually establishes the value of that business and its success in generating a profit, you may miss the mark in acquiring the value of that business along with the acquisition of the assets. And therefore, I think the value of a business and value in general, the concept of value, is a complicated one in a business context. It's multifaceted and it requires complete honesty from a business owner. In some cases, the answers may not be desirable. For example, a business's value may lie in a particular client account. It may lie in a particular sales representative or in a particular contract. or then which is relevant for present purposes, is it may lie in a particular intellectual creation, which may be a design or an invention or the like. So why the long story about value, you may ask? Well, it's difficult to protect value if you do not know the source of the value. And by mischaracterizing the source of the value, one may well end up covering crops that need rain as opposed to those that don't. Or you may end up wearing your cricket pads on your arms instead of where you are supposed to wear them, which is on your legs. You may protect something that is not worth protecting. You may cover something that is not worth covering. You may establish ownership of something that's not the true value of the business. Now, it's in this respect that I believe intellectual property often finds itself on the wrong side of the line. It's either overvalued as to its role in a business, or it's undervalued or disregarded. And in both such cases, I believe that the actual failure to address is not that intellectual property was inadequately protected. In many instances where there is an intellectual creation susceptible to protection, it is adequately and well protected. But to the contrary, a useless invention may be very well protected. But if it is useless, the fact that it is protected, for example, by way of a patent, would not make any difference. The actual failure, therefore, in my view, is a mischaracterization of that which allows a business to do whatever it does to generate profit and to do so in a profitable manner, or to generate revenue rather, and to do so in a profitable manner. So my goal here today is to try and contextualize intellectual property for you in a commercial context to inform a manner of thinking about intellectual property. I do not intend presenting you with the classical educational presentation dealing with the different types of intellectual property and the manners in which it may be protected. Therefore, if you walk out of here today, or in the context of our new way of working, if you leave the meeting today, I would hope that you did not learn necessarily any new information, but that you've obtained a new perspective on how to think about intellectual property in a commercial context. Now, something to consider at the outset is how do we characterize intellectual property? As you all probably know, intellectual property is in law regarded as being part of a category of goods called immaterial goods, as opposed to material goods that have a physical character. Therefore, immaterial goods exist separately or independently of material forms thereof. The picture on the screen, all of you would probably have seen in any intellectual property presentation that you've ever sat in, since this is the classic example that is used to discuss the various forms of intellectual property, being a Coca-Cola beverage product. We can, on the material goods side, discern various aspects of this bottle that are material in nature and fall within the scope of the law as it pertains to material goods. For example, we can discern the bottle, the cap, the label, if the label is removable, not in this particular bottle, but other bottles have removable labels, and then the contents of the bottle. Each of these is a material or is part of material goods. Ownership of these goods is obtained in terms of law of sale by way of a contract that specifies the goods to be sold and the price to be paid, and further, in most cases at least, by taking possession of the goods. The ownership, therefore, only passes in respect of the goods as is specified in the contract of sale. Ownership does not extend broader than the actual physical goods that are sold in terms of the contract of sale. It's directly related to the goods. Now, separately of material goods, the law recognizes that value may exist, and therefore the law provides for such value to be protected in relation to immaterial aspects of the goods. And specifically, we refer here to those that are created by human ingenuity. In the case of our example on the screen, these may include the design of the bottle, the trademark that's applied to the bottle or to the label, and the formula of the contents of the bottle. Obviously, being able to assert ownership over any of these, such ownership is going to extend much more broadly than that which is obtained through material property laws. since the ownership would exist independently of the material goods. Therefore, as I've mentioned now, the law provides for ownership to be obtained in respect of such creations of human ingenuity. And for the purpose of our discussion, I therefore label the subject matter of intellectual property intellectual creations. Underlying the whole concept that we are discussing is therefore the existence of an intellectual creation in respect of which ownership may be established, and the establishment of such ownership is desired so that the value of the creation may be protected. So please take that into consideration. We're distinguishing between intellectual creations on the one hand, and then the assertion of ownership in respect of such intellectual creations that would thereby establish them as intellectual property. So broadly speaking, I would characterize intellectual property, and please don't write this answer in an exam ever. This is just for the purposes of presentation and understanding. As I would characterize intellectual property as being an intellectual creation in relation to which ownership has been established in terms of the law, and as also including the legal instrument that protects the intellectual creation. And we'll look at some examples in the next slide. So if we look at intellectual creations, some intellectual creations that we may differentiate include inventions, designs, trademarks, so-called works that are susceptible to copyright protection, and we'll look at those in a minute. But those works may include musical works, artistic works, literary works, and the like. May include know-how, confidential information, trade secrets, all of those presented on the screen that I'm not going to deal with all of them. These are only a few. This is not presented as an exhaustive or complete listing of intellectual creations that the law may protect. Please do not therefore regard it in that sense. It's just an example to get a feel for what types of creations may be regarded as intellectual creations. Now, how we establish ownership in relation to these intellectual creations is, of course, dictated by the law as it relates to the protection of intellectual property. This is not something that I'm going to dwell on too extensively today, but suffice it to make some introductory comments about it. The first port of call is, of course, confidentiality. And this is so since something that no one knows of is, of course, very well protected. But unfortunately, something that no one knows of cannot always be used to generate revenue. I say cannot always because it can be used to generate revenue. For example, the Coca-Cola formula that I assume most of you will also know is protected as a trade secret. Therefore, no one knows what the exact formula of Coca-Cola is, but it is used to generate revenue. So, in all circumstances, confidentiality may not necessarily be a sustainable approach to establishing ownership of intellectual property, but in others it may. But both of those scenarios being considered, confidentiality should, in my view at least, always be the first step in working towards the protection of an intellectual creation as intellectual property. I say this because since, or at least once, confidentiality is breached, it can never be restored. And in addition, its breaching also influences the availability of certain registered forms of intellectual property protection, such as patent protection and registered design protection in particular. A general principle to take from today's lecture around the protection of intellectual property is therefore, as a general rule, to keep intellectual creations confidential for as long as possible so that you can keep both the options of sustained confidentiality and the option to acquire certain registered forms of intellectual property open and available to you. A failure to do so is fatal in both those regards in most instances. We continue discussing the protection of intellectual creations. Just as a summary, as you all may already know, inventions may be protected by patents, designs by design registrations, trademarks by trademark registrations, or in the absence of a registration, a trademark may be protected as the result of having established a clear reputation in relation to the trademark, which is in terms of the common law. Know-how is another form of intellectual creation, and that may be protected by some more unconventional ways of protecting intellectual property, such as documentation, restraints of trade, redundancy training, and confidentiality. Trade secrets is another form of intellectual creation that is typically only protected by confidentiality. But one should take into account in relation to trade secrets that a trade secret does not only need to be secret, it doesn't constitute confidential information only. It also has to have commercial value, and it has to have commercial value because it is secret. And then finally, the works that I have identified, literary works, works of art, and so on, these are all protected under copyright. Now, in each case, as you'll probably appreciate, we've therefore identified an intellectual creation on the one hand, and the means to protect it on the other hand. It must be emphasized here that in law, ownership, which is another word for protection, of an intellectual creation does not routinely arise as a result of having created the intellectual creation. And this is something that I really wish to emphasize today because it's something that I often run into challenges in practice. You still need to observe the legal requirements for ownership of an intellectual creation to come about. Therefore, just because you created something, it does not necessarily mean that you have an exclusive claim to it. You need to establish such an exclusive claim in terms of the law. And in most cases, and copyright is perhaps an exception here, but in most cases, this means you need to take additional steps after you've created the intellectual creation. And please flag this as a takeaway from this meeting, and I will discuss it again in a few slides from here, just to make sure we understand that concept and refer to it in a different context. Now, if I circle back to the core of our topic, I believe that it would be clear to you that there are few, if any, businesses, no matter how large or how small, in which an intellectual creation does not play a role in enabling revenue generation. And this is particularly, not exclusively, but particularly the case in businesses that rely on the exploitation and development of technology in their generation of revenue. The question that we are addressing today is whether and how intellectual creations and their protection, in other words, their ownership, are relevant to the commercial activities of a business. This is, of course, a completely different matter to the protectability of an intellectual creation, as I indicated in my introduction. And I think this is something that entrepreneurs should pay close attention to. And it's essentially this question that I would like to sensitize you today by hopefully expanding your perspective in relation to how to look at intellectual property and intellectual creations, not simply as something that you have developed and there is an option to protect it and therefore you will protect it, but to take an additional consideration in mind, which is how does this speak to the principles of my business and how does it slot into the principles of my business? And as a side comment that I've made to many clients is from a patent perspective, it's you honestly don't want to be in a position where the only person making real money out of your invention is the patent attorney who drafted the specification and prosecuted the patent applications. You should really consider whether, if that's the outcome that you ultimately achieve, whether your pursuit of intellectual property protection was indeed a sound commercial decision. Now, of course, if that were to come about, it doesn't mean that the decision was necessarily not sound. There are certain instances in which you have to engage in that process. You may have a funder that's not willing to fund you because you're not if you don't have a patent. So the circumstances in each case must be characterized and clearly understood. In this context, I should emphasize also that the ownership of intellectual property is not a precondition for commercial success. And therefore, if you own an intellectual property, it's not necessarily so that you will achieve commercial success. There are many businesses that are commercially successful without having established ownership of intellectual property. And similarly, there are other businesses that fail even though they established ownership of intellectual property. However, there are also businesses that fail or that don't perform as well as they ought to because they did not establish ownership of intellectual property. And what's key, therefore, is to understand your specific context and to strategize around that. And I may be repeating some of what I said earlier, but perhaps in a different context. If we consider the general value of establishing intellectual property ownership, I believe that one may view intellectual property being intangible property or immaterial property as analogous to material property. Establishing ownership over material property, for example, by purchasing a product such as that Coca-Cola product, that has particular advantages associated with it. These include the ability to exclude others from gaining benefit from the product, the ability to dispose of the product for financial gain, the somewhat crude ability to show off with the product, and various others. But in each case, one must understand that there's usually some or other clear motivation for purchasing and therefore establishing ownership of a product. And I don't think establishing ownership over intellectual creations and thereby creating intellectual property is any different, except for the fact that the product is substituted with an intellectual creation. And when considering intellectual property as a concept, I think one should therefore view it as an intellectual creation in relation to which ownership has been established, as I've pointed out. And here the principle, I think, should remain the same, in the sense that there should be a clear understanding of the motivation for establishing ownership over an intellectual creation, and thereby making it intellectual property. And this understanding, I believe, should most prominently take into account a business's commercial considerations. Now, this does not necessarily mean that the protection will directly improve your ability to make revenue, and we'll look at some other motivations in a moment. A second consideration is that where a motivation for the protection of an intellectual creation is identified, great care should also be taken in identifying a commercially suitable approach to its protection. There are, in many instances, various options available to the protection of intellectual creations, specifically inventions that may be protected in any one of several ways. And there's also the option of not protecting something, which is an option that must be considered in each discussion about intellectual property. Again, I circle back to what I said earlier, is that just because something can be protected does not necessarily mean it must be protected. You must still consider what the role of that intellectual creation in your value chain is, and how your protection of that intellectual creation will speak to your commercial position. Now, considerations that may play a role in the motivation for protecting intellectual creations as intellectual property may, of course, include any one or a combination of several aspects. And the character of those would depend on what the business wants to accomplish with the establishment of ownership of an intellectual creation. For example, a business may want to establish exclusivity in the sense that it wants to exclude others and thereby establish market dominance. In such a case, you must be sure that your pockets for litigation are fairly deep. If, depending on the nature of the market, of course, if there are real competitors to exclude. Another possible motivation may be to establish a basis for licensing the technology. Another possible basis may be to boost the company's balance sheet, or simply to show off, to show the business's clients that the business is at the forefront of technology development. And I have a corporate client that takes that view. They don't patent frivolously, they still patent inventions that we believe to be novel and arguably inventive. But the move to protect the inventions is to show that this company is at the forefront of solving its clients' problems. And they're not necessarily very litigious. They're not going to go ahead and sue everybody. But they want to show that this is what they are busy with. These are the technologies that they develop. Further possible motivation may simply be to create a minefield of patents for competitors that makes it very difficult for competitors to operate or innovate in the market. Now, of course, as the more difficult it is to innovate, one can argue, the better the innovations are that come out of trying to circumvent such a situation. But that's part of a more ideological discussion about patenting. And then another possible motivation that I've heard of is that is to patent inventions simply to throw other companies off the scent of what you are actually doing. But in all of this, the point to bring across is therefore that there's an individual motivation to pursue intellectual property protection in each case. And one should sit down and consider what the motivation is in the context of your particular situation, whether it is a business or the hope of a business, a startup or an established company, to consider the motivation for which intellectual property protection is going to be pursued. The first step is, of course, the identification of a creation. And then the second step is the justification for a pursuit of intellectual property protection in relation to that intellectual creation. One then moves on to the selection of possible approaches to follow in protecting intellectual creations as intellectual property. And you will appreciate that here the nature of the intellectual creation plays a very important role, since the available forms of intellectual property protection is determined by the nature of the intellectual creation. And it's worth reiterating here that creations that may find commercial relevance in the context of a particular business may include, as we have noted, and it's noted on the screen, inventions, designs, trademarks, know-how held by employees, institutional know-how, confidential information, trade secrets, artistic works, which may include technical drawings, literary works such as technical reports, policies and procedures, and then, of course, documented know-how as well. And it is in the identification of commercially important intellectual creations that businesses need to take care in being on point. That's the first step that I identified earlier. And the reason for this is that such an identification would ultimately be largely determinative of the intellectual property protection strategy that would be implemented. So in establishing a valuable intellectual property ownership position, it's essential for a business first to take the time to characterize clearly which types of intellectual creations are relevant to their commercial interests, and then secondly, to match those types of intellectual creations to the forms of intellectual property that may be used most effectively to establish ownership over these intellectual creations in the context of their commercial interests. And finally, the business should then decide which forms of intellectual property are a proper match for the relevant intellectual creations in the context of a business in the taking of a decision to move forward. There's, of course, an intermediate step that I omitted, which is deciding which of the intellectual creations identified is or are intellectual creations that should, in the context of the business, be protected. And I reiterate here that, again, as I mentioned earlier, simply because one or more forms of intellectual property protection may be available in relation to a particular creation, it does not immediately or obviously follow that it is an appropriate form of intellectual property protection in the context of the business. And I'll conclude with an example in this regard in some time as well. It's been my experience that where intellectual property considerations are given attention, and bearing in mind that sometimes they are not given any attention, an overemphasis is often placed on certain types of intellectual property. And in the case of technology-driven businesses, such an emphasis is most prominently on patent protection. On occasion, while patent protection is a very valuable and classical form of protection, the emphasis may often result either in patent protection being incorrectly selected as the best route for protecting intellectual creations, with other more relevant or potentially more relevant forms of intellectual property protection being sidelined. Or in other cases where patent protection is found not to be relevant, the result is that other forms of intellectual property are in the same stream, sidelined as being irrelevant or too onerous to pursue. And such an emphasis, I think, is blunt and fraught with risk to a business. And I believe it may be best illustrated with reference to computer program development as a example. I hope it's a simple example. And it's not only a good example from the perspective of the misalignment or the potential misalignment of an intellectual property protection strategy with business or legal considerations, but also from the perspective of ownership of the rights to pursue intellectual property protection. Now, while I speak of ownership, I need to interject and deal with it as a concept before I continue with my example as it relates to computer programs. I take into account here that, as I pointed out earlier, when I speak of ownership, I'm essentially referring to the right to exclude others from drawing benefit from that which is owned. And this is, in our case, an intellectual creation. The first aspect to point out is that the law does not recognize any ownership existing in ideas simply by virtue thereof that an individual came up with it, as I also mentioned earlier. And let me emphasize this point. The fact that you came up with an idea does not mean that you own that idea to the exclusion of others. You need to take further steps, as provided in intellectual property laws, in order to obtain such ownership. And this notion of further steps is also one that is an important takeaway that I would like to leave you with today. And that you should understand that after having created an intellectual creation, you need to investigate how to assert ownership in respect thereof in order to try and own it as intellectual property, and not simply to stop at the point of creation on an assumption that creation leads directly to ownership. And as I said, there are some exceptions, but the exceptions aside, let's assume, for safety's sake, that creation does not lead directly to ownership. At best, it leads to a right to obtain ownership through further steps. The Vodacom Please Call Me case, I think, is one that is relevant here, since that case is often regarded by people as being an intellectual property case, and it's actually more of a contract law case. And fortunately or unfortunately so, there's an article that came out this morning on it that I haven't read, that argues specifically, or I haven't fully read, but it argues specifically for or in favor of considering intellectual property aspects in that case, which have largely been omitted. But that being as it is, it stands that the Vodacom Please Call Me case is not an intellectual property case. The individual who came up with the Please Call Me idea did not take any further steps to protect the idea in terms of intellectual property laws. There were no confidentiality agreements signed, to my knowledge. There was no patent application filed. No further steps were taken. The individual concerned had a meeting with a superior at Vodacom, presented the idea, and the idea was then exploited by Vodacom, as is the version on record. And the argument in that case that is currently the subject of the big fight is that Vodacom undertook to pay him a portion of the revenue if they ended up implementing the idea. And this was not based on any intellectual property considerations. It was simply a verbal contract that was entered into. And the court recognized that the contract came into being, and that all that the contract omitted was the consideration that's payable, and that's, of course, what the current fight is about. But again, that case for me illustrates the importance of, at the very least, observing confidentiality and contracting clearly when an intellectual creation comes into being, and not to deal with it, and I'll use the word irresponsibly loosely here, but not to deal with it irresponsibly in a manner that may lead to great heartache later on. A second aspect to point out in relation to ownership, and I've also alluded to this earlier, is that in order to obtain ownership of an intellectual creation and thereby establish it as intellectual property, a right to do so in relation to the particular creation is first required. In other words, a right to be able to obtain ownership. The law affords this right, and this is something to take home as well, is that the law affords this particular right in particular circumstances to particular peoples or entities, depending on the intellectual creation concerned and the relevant form of intellectual property protection. And then, of course, importantly, subject to certain requirements being met. I emphasize here that if the requirements are not met, the legal requirements for a right to obtain ownership to come into existence, the intellectual creation may possibly not at all be susceptible to ownership. And this is something that may very well often be the case. And as I mentioned earlier, something that should be considered: is an intellectual property creation susceptible to being owned exclusively? Not all intellectual creations are susceptible to being owned exclusively, and that sometimes is the difficult answer to accept. In considering the possibility to assert ownership, knowing in the first instance whether the law recognizes the relevant intellectual creation as one that is susceptible to being owned in the specific circumstances, and then secondly, knowing the identity of the relevant people or entity to which the law affords the right to obtain ownership, is therefore crucial. And I think the computer program example is one that should illustrate this. Now, getting all the way back to my computer program example. Computer programs as such are expressly excluded from patent protection, and therefore an overemphasis on patent protection may readily result in intellectual property considerations falling by the wayside. If you ask the question, can I patent my computer program? And the answer is no, you think, oh, well, that's the end of the road, and you just carry on with your life. Now, as most of you may know, however, computer programs are specifically protected under the Copyright Act in South Africa. And in the case of computer program development, copyright considerations must therefore weigh very heavily. Although patent considerations cannot, in light of some recent developments, be left by the wayside, particularly in machine learning and artificial intelligence applications. There are quite a few foreign patent offices that have started to recognize various conditions for the patentability of computer implemented inventions. But it stands that a computer program as such, the program itself, that is not directly susceptible to patent protection. Now, in this context of computer programs, it must be understood on an ownership level that copyright can only pass from the author of a computer program or of any work susceptible to copyright for that matter to another person in limited circumstances without a written assignment being required. In all other cases, a written assignment is necessary. And one case in which a written assignment is necessary from a copyright perspective, and actually generally from an intellectual property law perspective, is the case in which one uses an independent contractor, not an employee, an independent contractor to perform work. And here I think one should pique one's ears that where an independent contractor develops a computer program for a client, the fact that the contractor is being paid for their work does not in itself result in the copyright in the computer program being transferred to the client. A written agreement to that effect is required. The law therefore recognizes not the person paying as the person being the one acquiring the copyright, in other words, the intellectual property. The intellectual property is recognized by the law as being owned by the third-party contractor. So in the absence of such a written agreement, all that the client would end up acquiring from the program developer is one or more copies of the computer program. They would not acquire the right to make copies or adaptations thereof. And while it's not so in all instances, in most instances, so the making of copies of computer programs is a way in which revenue is generated. And the client may therefore find itself in a very difficult commercial position later on if it did not clearly understand the law as it pertains to the ownership of intellectual property of computer programs. And I think that this illustrates the more general point that I wish to make, that one should be cautious and circumspect in considering how to establish an intellectual property ownership position, and then to do so in a manner that's aligned with the business's commercial considerations. In some cases, the copyright may not be necessary. You just want to develop a computer program so that you can use it in-house and you just need one version of it. So be it, then you don't need to worry about copyright considerations. But if the intention is to make money, to generate revenue through the sale of copies of a computer program, you need to acquire the copyright. So in all of this context, one should, of course, also understand, as I've also mentioned, that there are many cases in which an intellectual creation simply is not susceptible to protection. But that's a conclusion that I would advise one rather to arrive at through a process of investigation than simply to assume. Speaking practically, and bearing in mind that I'm today not lecturing you about all the forms of intellectual property protection that may be relevant to a business, in developing a valuable intellectual property ownership strategy, particularly when confronted with technology development, I believe that contracted confidentiality, as I've mentioned earlier and as I now want to expand upon, contracted confidentiality may be viewed as the most useful tool that is at the disposal of a business at the initial outset of dealing with intellectual property, and one that I think should be employed until clarity has been obtained as to whether and the manner in which ownership over intellectual creations relevant to the business may be established. As I mentioned earlier, a failure to do this has a variety of potentially negative consequences, including the destruction of the ability to rely sustainably on confidentiality and also the ability to pursue patent protection. Generally, I therefore regard observed and, where it's necessary, contracted confidentiality as a sound starting point of an intellectual property ownership strategy from which one would then develop an informed approach that is business oriented. Once confidentiality has been observed, and if it is relevant, confidentiality has been contracted, and this has now been established, a business may then branch out into deciding which other avenues of intellectual property protection may be available, and then consider whether these are suitable in the context of the business. A final comment that I wanted to make in relation to contracted confidentiality and more generally the protection of intellectual creations as intellectual property is that characterization of the relevant subject matter is very important. Such characterization would ultimately determine whether information is confidential or whether it is not. And in cases where you are confronted with other types of contracts, such as now licenses and the like, the lack of characterization may in litigation be very challenging to the one seeking to enforce it, since there is uncertainty about the subject of the license. In relation to confidentiality, you don't want there to be uncertainty in relation to the information that is actually being protected as confidential. To use a simple example to explain characterization, it may be known in the market to manufacture scaffolding, for example, of various materials. You can use bamboo and you can use metal. And I then go and I decide to establish a business in the manufacturing of metal scaffolding. I decide that in my mind. Now, obviously, I cannot claim confidentiality in relation to the fact that scaffolding can be made of metal. If I have a conversation with a friend and I say, yeah, I know, I don't know if you're aware, but you can make scaffolding of metal, or of course you can make scaffolding of metal. and of bamboo. And metal, I hear, has got the following advantages. There's no confidentiality in that discussion. You cannot contract confidentiality in relation to it. But I can assert confidentiality in relation to the fact that I intend establishing a business in relation to the manufacture of metal scaffolding. If my discussion with a third party is around that characterized subject, I may very well be able to assert some form of confidentiality in that. So consider that carefully, that the characterization of information may very well ultimately determine its susceptibility to protectability or not. Now, to tie all of this together, and moving toward the end of my talk, I'll conclude with an example, as I suggested I would. Take, for instance, a company that develops a new flotation process for the recovery of a certain metal through flotation. The process relies on a particular additive that is used in the flotation cell. This additive is a new additive that's never been used before to the assessment of the company. And they conduct experimental test results. These are contained in technical reports. And the company then finds that the additive has a significant effect on the recovery efficiency of the metal when it is used in a broadly defined concentration in the flotation cell. But in addition to this, the company knows that if it is used in a more narrowly defined concentration, in combination with the specific operating conditions that the company uses in its particular flotation operation, which it developed over a period of several years, and which is the knowledge of several individuals. If it uses the additive in this narrower range, the technical effect that is achieved is significantly more commercially valuable than operating at other ranges in the broader range. Now, if one takes into account that there is no ownership of ideas, the company needs to understand that if word of the additive gets out in the market, they would not be in a position to protect themselves against its exploitation by other companies. Now, yes, this is very nuanced, and you can make all kinds of arguments about stealing of trade secrets, but then the question arises, well, is this a trade secret? Because it doesn't really have proven value in commerce, but it may yet have. So you get into a very dirty fight at that stage if information leaks out and you want to put it back in the box on the basis of common law principles. So those principles aside, if the company is in a position in which they do not want to sit in and have that fight down the line, they need to take, as we have discussed, further steps after having created this intellectual creation in order to assert ownership in respect of it. Firstly, however, they need to identify the relevant intellectual creations, as we've discussed. Ones that I've identified here are literary works in the form of technical reports, and invention in the form of the technical principle of using this particular additive in a flotation cell, and then thirdly, know-how, which is the know-how of the employees of how the flotation cells generally operate. The company now needs to decide which of these creations, if any, or perhaps all of them, is or are worth protecting as intellectual property. And that's ultimately a commercial decision that one has to consider and weigh up in light of the available forms of protection, which is the third consideration. How can we protect these intellectual creations from an intellectual property perspective? And as I've said most recently, my view would be to start with contracted confidentiality. The first step would be to ensure that everyone who has access to information about the invention and the know-how is bound by a confidentiality agreement. And then further, to implement information access control protocols, so you don't have people accessing the information who are not bound by by confidentiality agreements. Secondly, I would consider patent protection in the context of the risk of disclosure. Obviously, as I've mentioned, the company does not want word of this additive getting out in the public domain. And patent protection is unfortunately a form of intellectual property protection that necessarily results in disclosure. You cannot keep something secret and put it in the and patent it. The two are mutually exclusive. So when looking at patent protection in this context, perhaps the company would consider, and again, there are various motivations, but in this context, I'm discussing one particular motivation, is they may consider the risk of this information getting out in the public, because once it's out there, you can't do anything from the scope of our current discussion to get that information back into your hands on a basis of exclusivity. If the risk is high, they may say, well, let's rather than put it out in the public domain and pursue patent protection because we believe that we comply with the requirements being novelty and inventiveness. So again, we have the intellectual creation, we have a motivation for protecting it, we have the intellectual property protection instrument, patent protection, that we've identified, and now we've identified that we believe we comply with the requirements. Now we need to take still further steps and protect this invention as a patent. In that discussion, one can consider then possibly not including information in the patent specification relating to the narrower range of operating in the context of the specific flotation cells of this company. And in that area, you would then have in parallel a patenting process and secondary or in preference to that, a trade secret process. In relation to the trade secret process, the observance and contracting of confidentiality then becomes essential. You cannot just call something a trade secret. You actually have to make it a trade secret. You have to take steps. Finally, turning to the know-how, I would ask myself in considering whether to protect the know-how, to which extent I'm comfortable that if I no longer have access to the relevant employees who have the know-how in their heads, I would still have the benefit of the know-how. And here I may decide as a protection mechanism to train up other people to create some redundancy in the role and to have some of the know-how documented so that I can thereby separate it from the people which hold it and thereby protect it in that manner. And one should have a broad view of know-how, I believe. Know-how can be something as seemingly straightforward as keeping administrative records of a particular attorney's practice or running the accounting system. My secretary has a wealth of know-how about how my practice is operated. If I lose her, I have to train someone else. Unless I get her to train someone else now, or I get her to write down everything and thereby protect the know-how. One should be cautious in a situation where know-how that is of significant commercial importance sits only in the head of one individual. That's an extremely risky position to be in, and one that should be considered carefully as to how it should be protected in the context of the business. I'm concluding. In conclusion, I would like to emphasize again that my message today of the need for a business to take time to understand the role of intellectual creations and then to strategize accordingly around the establishment of intellectual property ownership is critical. If one misaligns these considerations, being the considerations being on the one hand a business's commercial considerations and its intellectual property ownership strategy, it may have severely negative consequences for the business down the line, and work should be made early on to avoid that. These negative consequences may be wasteful expenditure on the one hand, or an extremely exposed position on the other hand. The overarching thought that I would therefore leave you with today is to say that in considering the protection of intellectual creations as intellectual property, the fact that a certain form of protection is available does not necessarily mean that it is suitable from a commercial perspective. or necessary to pursue from a commercial perspective. The questions to be asked are whether the relevant intellectual creation has an enabling role in the context of the revenue-generating activities of the business, whether it's capable of being protected, whether it's advisable to protect it in the context of the business, and then which type of protection would best suit the commercial interests of the business. If one takes that approach, in my view at least, you would have gotten to a rationally established position that you can defend later on, and that should ultimately be aligned with the interests of your business. Thank you very much.